Nice. Okay, is that up? Whoops, let me present from the start here. Is that working?
Yep.
All right, so my presentation is going to be on administrative law, the very basics of administrative law, and just, whoops, yeah, before we start, just nothing in here should be taken to be legal advice, which I'm not qualified to give. Any of this might also be wrong because Columbia went to pass-fail due to the coronavirus. I never got a grade in admin law, but I did pass. So this is at worst a passing presentation. I'll start off just with a quote. Administrative law is not for sissies, so you should lean back, clutch the sides of your chairs, and steel yourself for a pretty dull lecture. And after he said that, then Justice Scalia gave, I think, a pretty interesting lecture, but this will, I doubt, be that interesting. But hopefully it'll still be fun, and you'll see why this area of law, I think, is one of those that's more relevant to ordinary people's lives than we realize. This is just a little outline of how it's going to go. First, I'll just explain how agencies are structured and the history of the sort of standard form that came to exist, the basic functions they perform with examples, and then some controversies in agency and administrative law that are still unresolved. I don't know why it's going back. Okay, so first, the sources of federal law, you're probably pretty familiar with statutes. They're in the US Code. When someone says the law, that's what jumps to mind. They're passed in the way that you're familiar with from grade school. They're drafted by Congress, passed both houses, and signed by the president, and they can be repealed by later statute or by a court decision rendering them unconstitutional. This is mostly going to be about regulations, which are in the Code of Federal Regulations. And as I'll explain, they're written in formal and informal rulemaking procedures, and they're also written in agency hearings. Just like statutes, they carry the force of law. Unlike statutes, they could be repealed by an act of Congress or by a court decision or by a subsequent rule. But the important part is they're not passed through the ordinary legislative process, but they're just as much the law as statutes are. Agencies you're already probably fairly familiar with. They're generally divided into executive and independent agencies. So any executive agency is one that's contained within a cabinet level department. So here, just some examples. The FAA is part of the Department of Transportation. The U.S. Fish and Wildlife Service is part of the Department of Interior. The FDA is part of HHS. And they're all overseen by a cabinet secretary who the president selects, they appoint, they're confirmed by the Senate. And the president, though, can remove them at will without the consent of the Senate. So the president has a lot of control over those agencies because they have control over the head. Independent agencies, on the other hand, the president has less control. They're generally subdivided into regulatory agencies over which the president has very little control, like the SEC. I'm not sure how many commissioners there are, or the FCC, the Federal Communications Commission, has 3 commissioners who I believe sit for like 7-year terms, and they can only be removed basically for malfeasance or if they resign. So the president has a lot less authority over those. There are also executive independent agencies, which generally are more.
The president appoints those people?
They do. So the EPA has an administrator of the EPA. Typically, executive independent agencies have one head. Like there's a single administrator of the EPA. There's one CIA director, etc. They're generally removable at the president's request, and you don't have to have cause or anything. Whereas for, the SEC, the FTC, the FCC, the Fed, you do. There are 185,434 pages in the CFR, the 2018 edition, and you can see how it's grown over time from less than 10,000 pages in 1950 to almost 200,000 today. So a huge amount of American law is in the CFR. The history generally, the APA is what governs all of this. before the APA was passed in 1946, especially with the New Deal, which created a lot of powerful agencies, there was essentially no unified agency law, and they all just did things their own way. And there was no real way to challenge agency decisions. And it was highly controversial because at the time, this was sort of about the legacy of the New Deal. Do we want, strong oversight of agencies or not? But fundamentally, there are four basic purposes. It's to require agencies to keep the public informed of what they do, to allow the public to participate in rulemaking, to establish uniform standards of rulemaking, and to allow for judicial review. Agencies are interesting because while they are technically within the executive branch, they can serve as legislatures by writing regulations. They also enforce those regulations, and they resolve their own enforcement in front of judges who are actually employees of the agency. So first, the way the rules are written, they're generally done in three ways. Formal rulemaking, which requires that the agency publish a notice. There's a hearing that's a lot like a court hearing with evidence on the record. You'd have witnesses and examination. And then there's informal notice and comment rulemaking, which basically notice is published, the public is invited to comment, and they essentially publish a draft and say to the public and to regulated industries, what do you think about this? And they'll respond to comments before issuing a final rule. It's fairly similar to formal rulemaking, but there's no actual in-person hearing. Then the last way is during when agencies enforce their rules, during an adjudication of an enforcement, they can decide a new principle of law. It can't apply to the case they're hearing at the time, but it will apply to future cases. When an agency wants to change a regulation, the process is exactly the same. It's just like enacting a new one. They have to acknowledge that they're changing the rule, but there's no need, an agency doesn't need to say, we've considered the alternatives and here's why this new one is better than the old one. They can just change it, so long as it's reasonable. And here's an example of that process in action. So the Clean Water Act, which was passed, I think, in 1976, is a huge sweeping law that regulates pollution, but it only applies to waters of the United States. And the statute doesn't say what that means. So you can dump whatever you want into a river if it's not a water of the United States. But if it is, the Clean Water Act applies. So essentially, the EPA had the job of figuring out what a water of the United States was, and thus what the Clean Water Act would apply to. So the original rule was called the Migratory Bird Rule, which meant that any body of water that migratory birds used or could use counted as a water of the United States, which obviously was almost any body of water in the country. And that was overturned as too broad and almost meaningless in 2001. So after that, the Obama administration tried to create a comprehensive, sort of sensible rule that would solve those problems. So they started with any water that is navigable and any water that crosses state lines, and then any other water which could essentially harm interstate commerce if it were polluted, particularly those that are used for recreation, fishing, or industry, and then any waters that are adjacent to or connected to or tributaries of one or two. And that was pretty clear. I believe it was finalized, that rule, in 2015, and Trump campaigned on repealing that rule and replacing it. So it lasted not very long. And then just about 6 months ago, the Trump administration finalized their new waters of the United States rule, was basically just only navigable waters and then wetlands that are connected to those. So it really narrows the scope of the Clean Water Act. And Trump famously said this after signing it, and I signed that, this he's talking about the waters of the United States rule, and behind me I had home builders and farmers, mostly and ranchers. Many of them never cried in their life, including when they were born. Oops. And they were crying. It's true, though. They were crying behind me because we gave them back their land. So it was really controversial for a long time, and it was seen as a huge power grab by the EPA. And so, for better or worse, it's limited now. Agencies also resolve disputes through either formal hearings, which are governed by the APA. They, much like a hearing before a real judge would have notice, you'd have evidence, you'd have cross-examination, you'd have lawyers, you'd have a decision based only on the record presented at the hearing. They're held before what are called administrative law judges, or ALJs, who are lawyers who are employed by whatever the agency is. And I think they are selected to serve a specified term that can be extended, and it usually is. They're distinguished from so-called Article III judges, which are like typical federal judges who get their power from Article III of the Constitution, who serve for life and are confirmed by the Senate and picked by the president. ALJs are just agency employees who get picked to be judges. Then there are also informal adjudications, which are about 90% of how disputes are resolved, and they can take any number of forms. So like Social Security determinations, like your disability benefits, you think that you deserve more, you file a petition of some sort, and it's resolved somehow. You have very little due process rights. Basically, there's just a right to get a copy of whatever the record is that they base their decision on, and a right that a decision is made somewhat promptly. And yeah, it's usually used for benefits determinations, permits, licenses, stuff that doesn't involve small issues generally. So then finally, I don't really have an example for that because it's wrapped up with an executive. So agencies also enforce the laws, both statutes and then their own rules and regulations. They can bring an administrative proceeding before an ALJ. They can file a civil suit in an ordinary federal court. I'm sure they can do it in state court too. And typically the penalties for those are more severe than an internal proceeding. Like in an internal proceeding, let's say by the SEC, you might lose your ability to participate in securities trading, or you might have a permit suspended. But in a civil suit, you could have to pay penalties. You could be barred from the industry by court order. You could be enjoined from doing certain things with the force of law, and you'll be arrested if you don't comply. And finally, they can recommend, they don't prosecute criminally, but they can recommend to the Department of Justice criminal prosecution. Oftentimes you'll see in a big case, both, all three, or you'll see a civil suit and criminal prosecution. And I've got some examples of that too. So first, this is an example of an administrative enforcement. I'm not a big Barstool Sports guy, but the president of the company tweeted after there was some media unionization efforts. He tweeted pretty negatively about that. Someone suggested, you can reach out to me if you want to form a union. And he said, if you work for Barstool Sports and DM this man, I will fire you on the spot, which is illegal under the National Labor Relations Act. So he tweeted, he made that threat. Later that day, the AFL-CIO filed an unfair labor practice charge with the National Labor Relations Board. And a funny thing about the NLRB, anybody can file a charge. You don't actually have to be an employee of the company. Anybody can do it, and it'll still be prosecuted, or it'll still be looked into in the same way. So about 6 months later, they settled. The president had to delete the tweet and post notices both on the posting boards in the same way that you would normally post, I think that's the language, signed and written by him personally, reminding everyone of their right to unionize. He also had to email that to everybody. And they had to delete a video called Professor Nate Explains Unions, which I assume was some sort of anti-union thing. So that was held before an ALJ. It reached a settlement, or I doubt there was actually a hearing, but that was all internal. The NLRBs basically said, hey, we're looking into you, and Barstool settled. Here's an example of civil enforcement in court. On August 7th, Elon Musk tweeted, I'm considering taking Tesla private at $420 a share, funding secured. Funding was not secured. And a couple weeks later, September, but I think it was about 2 weeks later, the SEC filed a civil suit in the Southern District of New York, which is the Manhattan Federal District Court, alleging that Elon Musk had committed securities fraud. And basically he had tweeted that to artificially inflate his share price, which was way below $420 a share at the time. This is the federal courthouse in Manhattan. Actually, that building over to the left, I worked there last semester, 1 day a week. It's just a fun little personal note from me. 2 days after that, the SEC and Elon Musk settled. Musk agreed to pay a $20 million fine and resign as Tesla's chairman. But a couple months later, before the settlement was actually finalized, Elon tweeted that Tesla, quote, will make 500,000 cars in 2019, even though Tesla had told its investors that it was only going to make 350 or 400,000. So right, like the day he did that, the SEC asked the court to hold him in contempt for violating their earlier settlement. So after a little more negotiation, they agreed to a second round of settlements with no additional penalties, but with the requirement that Tesla's lawyers sign off on any of Elon's tweets that were material to Tesla's securities price. So nothing about production numbers, nothing about stock price, essentially that sort of thing. And I think he's gotten himself into hot water like 4 more times since then. This is an example of criminal enforcement. I'm sure you guys know Martin Shkreli, who actually only went down for securities fraud, but he was charged criminally with securities fraud in the Eastern District of New York and sentenced to 7 years in prison and a $7 million fine. But also he was sued by the SEC, and they sought to bar him permanently from participating in the trading of securities. To the $7 million is a fine for the criminal activity, and in the civil suit, the SEC was looking for disgorgement of his ill-gotten gains, basically, and then further penalties. And then I have some quotes here from jury selection in that trial, which I really enjoy. So the purpose of jury selection is to ensure fairness and impartiality. If you think you could not be fair and impartial, it's your duty to tell me, all right, juror number one, I'm aware of the defendant and I hate him. And then his lawyer says, I'm sorry, juror number one, I think he's a greedy little man. Do you agree that juries are obligated to decide the case based on only the evidence? I don't know if I could. I wouldn't want me on this jury. Then juror one is excused. Juror 52, when I walked in here today, I looked at him and in my head, that's a snake. Not knowing who he was, I just walked in and looked right at him and that's a snake. So much for the presumption of innocence. Juror 59, Your Honor, totally he is guilty and in no way can I let him slide out of anything because then, okay, is that your attitude toward anyone charged with a crime who has not been proven guilty? It's my attitude towards his entire demeanor and what he's done to people. All right, we're going to excuse you, sir. And he disrespected the Wu-Tang Clan. So that's sort of what agencies do. Then the final aspect of admin law that's worth noting is statutory interpretation. So just like the Clean Water Act, when courts write a statute, it's often fairly vague and it has parts of it that might be contradictory or confusing. And courts essentially have to sort out what the statute actually means. And I've just put a few tools that courts and agencies use. They'll look to the legislative history. You know, what did the drafters at the time say? What was the point of the statute? What was the problem it was trying to solve? Then look to other statutes. How do other statutes use the same phrase or words? And again, how does this fit with statutes that came earlier and that came later? Then you have grammar rules where you get Latin. Both of these essentially mean the same thing, but they're basically like if you have a list of 3 terms, if you have like cars, trucks, or any other vehicle will usually be read to just mean vehicles with wheels. Planes probably wouldn't be included. And nascitur asociis is you'll know it by the company it keeps. You also have strong statement presumptions, basically like if there's a strong principle like federalism, the federal government's not supposed to pass laws that infringe on states' rights. Congress can pass laws like that, but if they want to do it, they have to be very clear. And I have an example of that as well. This guy was caught in the Gulf of Mexico fishing illegally. He caught a bunch of undersized fish, and a Coast Guard or National Marine Fisheries Service boat approached him and basically said, hey, we need to inspect your cargo. They found undersized fish. And so the guy running the boat said to Yates, meet me back on shore. And when we get there, we're going to measure all your fish and we're going to figure out what the fine is. On the way back, Yates dumped the undersized fish overboard. They were red grouper. That's what the picture is. So he was charged criminally under 18 USC section 1519, which makes it illegal to knowingly alter, destroy, mutilate, conceal, cover up, falsify, or make a false entry in any record, document, or tangible object. So this was a Supreme Court case, and the question was, is a fish a tangible object for purposes of this statute? And you would say, obviously, yes, you can hold it, you can touch it in your hands, it's tangible. But the other argument is, well, no, because clearly this statute is about records, and it's about hiding them or destroying them or faking them. And also, this was passed as part of the Sarbanes-Oxley Act after Enron. So the whole point of it is commonly known as the anti-shredding provision. The whole point was to prevent document destruction or document falsification. So, literally, yes, a fish falls into this, but should it really? And the court said, no, it doesn't. A fish is not a tangible object for purposes of this. And which I always thought was pretty interesting. And that's also an example of typically when there's ambiguity in a criminal statute, the idea is it's supposed to be resolved in favor of leniency. That pretty rarely happens, but it's supposed to happen, and it happened here. Agencies, of course, because they enforce federal laws, have to do a lot of interpretation on their own. And courts, the way the law has developed, don't actually second guess the agency interpretation. They defer quite heavily. The case is Chevron versus the National Resources Defense Council. It's pretty famous. Basically, all the court will say is the statute actually ambiguous, or can it clearly be looked at? And the court will say, oh, actually, this isn't ambiguous at all, so the agency didn't need to resolve it. But if it's ambiguous, the agency's interpretation only has to be reasonable. It doesn't have to be correct. It doesn't have to be what the court thinks is right. It just has to be reasonable, which is, it's what it sounds like. It's pretty broad. And agency interpretations win more than 3/4 of the time. And basically that means if you go up against an agency and you say, hey, I don't think this is right, I don't think this is a water of the United States, you're probably going to lose. Chevron is one of the biggest controversies going in administrative law. This is what Neil Gorsuch said before he was on the Supreme Court. Chevron permits executive bureaucracies to swallow huge amounts of core judicial and legislative power and concentrate federal power in a way that seems more than a little difficult to square with the Constitution of the framers' design. Maybe the time has come to face the behemoth. Chevron has been on the books for at least 40 years. It's been chipped away at over time, and now there's a big question of whether this Supreme Court, the current court, will overturn it finally if they get a good case to do it.
I have a question about that.
Yeah, sure.
So from like a power perspective, basically Gorsuch and his ilk would rather see the power for making these decisions held by the Supreme Court than held by administrative agencies. Pretty
much, yeah. Typically, it would be held by lower federal courts because most of these issues are going to be resolved at the district court level. So the APA, under the APA, if you're aggrieved by an agency action, you can basically appeal it to a federal district court, which is the lowest level of federal court, and they would be the ones to say, here's what the statute actually means. And of course, you could eventually appeal it up to the Supreme Court, and for an important central issue like the waters of the United States, it would make it there. But generally, yeah, they want the courts deciding this because under the Constitution, courts are supposed to interpret the law. Agencies aren't provided for at all. This is, to me, a really interesting chart, and you can see the red bars represent Republican administrations, presidential administrations. The blue ones represent Democrat presidential administrations. So you can see generally, at least, Obama passed quite a lot of regulations. It's also interesting to see in the final year in office, they tend to pass quite a lot. And I'm not sure if that's kind of like a lame duck thing or if that's because rules actually, they take quite a while to write with the notice and comment and the review and the revisions. So it might just be that, that process speeds up towards the end of the tenure. And you can see that rulemaking is way, way down under Trump. And I believe one of his first executive orders was required that for every new regulation an agency writes, they have to remove 2, which is a sort of interesting way to do it. I don't know how that's enforced. I don't know what's to stop them from kind of repealing bullshit ones, but I guess, if you're the president, you replace all these agency heads anyway, so they're probably pretty, they got guys in there who want to deregulate. But finally, I just want to touch on some controversies in contemporary administrative law. The first is there too much deference? Basically Robert's question. And what's interesting is agency interpretations right now can win even if a federal court has already decided that their interpretation has. Or let me start again. If a federal court has interpreted the same statute and has decided that it means one thing, if an agency decides it means another, the court is still supposed to defer to the agency. And that would only really happen, I don't know how familiar you guys are with the federal court system, but it's split up into 11, is that right? I think 11 circuits geographically. So like if the Ninth Circuit in California decides it means one thing and the agency comes before the First Circuit in Massachusetts, the agency interpretation is supposed to win. In the Ninth Circuit, they'll lose because the court has already said one thing. But actually, I think in the Ninth Circuit, they'd still win unless the issue was raised in a particular way. And it's an open question of whether that would even prevail if the Supreme Court said that it should be interpreted one way. As long as the agency's interpretation is reasonable under Chevron, it should still win. So that's a big point of contention. And to your point, Robert, somebody like Gorsuch, I'm sure just like seethes at thinking about the mighty Supreme Court being told what to do by like some ding dong who didn't go to Yale Law School. But that's how it is now. Our agency is full of unaccountable bureaucrats who, make the law as they see fit with they're totally unaccountable to election other than like the trickle down effect of a president replacing them. Kind of. They can't be replaced by elections. You or I or anybody has no idea who the people who write these laws are. Our agency interpretation is too subject to change. Unlike statutes that can sort of be changed at will, it's a slow process, but it can be done. Our agency adjudication is fair. When you think about it, an agency is enforcing rules it's written in front of a judge that's its employee. And does a strong administrative state violate separation of powers, which is similar to the others? They're writing laws, they're enforcing them, they're interpreting them. But then also, is Congress actually able to legislate without agencies filling the gaps? Because when you think about something like the Clean Water Act, that's, I don't know, a couple hundred pages of statute and probably 30,000 pages of regulations interpreting it. And if you wanted Congress to sit down and define every last thing and say, for example, the EPA has to every year come up with what's an acceptable amount of lead for a power plant to put out, what's an acceptable amount of all these pollutants. If you want Congress to do that every year, that's not really realistic. So somebody has to be doing this work. And that's it. And I would welcome any of your questions about it.
So for the judicial components of all these different agencies and I guess the judges that they have within their internal system, are those guys typically like lawyers and judges, or could they just be employees that are familiar with the system?
Yeah. If they're an administrative law judge, they're a lawyer. I would think that for some of the informal adjudications, like Social Security appeals or like things of that nature, like permits, it's probably being decided just by an employee who's an expert. And I would think they probably have agency lawyers they can consult. But when the issues they're deciding aren't really legal ones, they don't necessarily need to be decided by an ALJ. And it's important to point out that ALJs aren't like, it's not like they go around and say, oh, you were a state court judge for 3 years, we got to hire you as an ALJ. It's like you get hired to work at an agency, maybe you work drafting regulations for 5 years, and then you apply to be an ALJ and they hire you for that. Or, you've been a practicing labor lawyer for 10 years, you see a posting for an ALJ opening at the NLRB and you apply. That's more how it goes.
So like an internal system.
So I guess going back to the example of the fish, just as a kind of prudent example, when it comes to enforcing these, how much leeway and interpretation do the actual enforcers get? Like the guys who arrested the fishermen for throwing over the undersized catch, like how much leeway do they have to arrest the guy under the statute that was cited?
Yeah, that's a great question. There it was the Department of Justice who actually prosecuted, but it's basically the same principle applies to all of them. typically I think an agency would have a position on whatever the ambiguous thing is, and they would, in addition to rules, agencies also often will issue policy statements, they're called, or like interpretive notices, which basically say, this is what we interpret this to mean. And those decisions I don't think are ever made at the like enforcement level, but like the ATF is a big one. Like the ATF and the IRS come to mind as like, you can write a letter to the ATF and say, hey, is this gun that I've created illegal? And they'll respond and they'll say yes or no. And like bump stocks, that was a big thing. I think after the Vegas shooting, they basically issued a policy guidance saying, we consider bump stocks to be automatic weapons and therefore illegal under the National Firearms Act.
As an addendum, do not write a fucking letter to the ATF.
Yeah.
They will never side in your favor. Let ambiguity exist. Do not ask them questions because they will answer them. We don't like answers.
Yeah. The IRS too, you can write a letter to the IRS, although they're actually, people say much better about it, and they will write, like the IRS in particular, there's the Internal Revenue Code, but a huge amount of the actual like tax law of the US is basically contained in like ephemeral responses to people's questions. And so if you want to be a tax expert, you got to read all that shit. And the EPA too, like if you're a company, I don't know, Robert, I'm sure 3M has to do this all the time. Like there are definitely parts of environmental law that probably are only really known to like 3M's and environmental compliance lawyers and like a couple people at the EPA.
So these letters that you talk about, like obviously like they're not going through court. They're not. I imagine they're not like highly publicized. A company doesn't want to be caught with its pants down. Do these agencies, I don't want to say release like a monthly newsletter saying like, hey, these are questions we were asked and these are our positions on the questions?
Yeah, they do. I believe that there's basically there's something called the Federal Register, which is kind of exactly what you described, but it's for all agencies. I don't know how often it's published. I think it's probably monthly. It might be quarterly, and that has all of that stuff in it. But some of them are even less formal than that, and those would be. I mean, you might find them on an agency's website, but the IRS, at least, they literally just mail letters to people. And there's probably somewhere that they post them or like somewhere they keep a copy. And if you call them up and say, hey, can I get copies of all the letters you sent this month? They'll give them to you. And it wouldn't surprise me if like private legal publishers do that regularly and put out their own versions. But like, it's you have to really do that if you want to keep up with it.
That's interesting.
So you kind of got at this with ATF, but how many of these agencies have their own cops, basically?
Generally, yeah, that's a good question. I've looked into it for unrelated reasons. It's mostly the ones that are part of cabinet departments. So like executive agencies, like the SEC doesn't really have cops. I mean, they have, when you say cops, you mean like, all of them have enforcement lawyers, but you mean like investigators, basically?
I mean investigators, and
investigators
I mean
are
people
law
who like walk
enforcement, people
around
with
carrying
guns,
basically.
Yeah.
Exactly.
I think honestly, a lot more than you expect do. Like the EPA does.
Right.
I don't know that like the Department of Labor does, but like with all of them, it wouldn't surprise. Like it's the same with ALJs. Like the Social Security Administration has like 1,500 ALJs because they have such a high volume. Whereas like the Department of Transportation has like 6. And it wouldn't surprise me if pretty much all those agencies have uniformed cops somewhere.
Yeah. I was going to say my experience with the EPA
more
is they'll send an engineer to you. They won't send a cop to you, but that might be because you work for a company rather than you're dumping stuff or whatever.
Yeah, I know that like we would joke in environmental law that, and I've seen people joke, like if we're going to have like, if every aspect of the government is going to be militarized and like local police are going to be militarized, at least like the DOL should be militarized. And like if someone is committing wage and hour violations, like they should be visited in the middle of the night by like a rendition team and taken to some sort of like black site in Afghanistan. But that seems unlikely.
So like an example of one of those enforcement, I guess, arms would be like game wardens. Don't they technically fall under Department of the Interior?
Yeah, I think it depends a lot. I know at national parks and like uh, places like that, they definitely do have armed rangers or wardens or whatever as the case may be. Yeah, that would fall under it. ATF for sure does,
Yeah.
and like the DEA, all of those have tons. U.S. Postal Inspection Service.
Really? Huh.
Yeah, postal cops I think are regarded as some of the better investigators in federal law enforcement. At least that's my like understanding.
Yeah, they have whole like branches that are dedicated to like mail fraud and like basically any crime that's committed. So I listened to a podcast on it like a while ago. Like any crime that's done via the mail, like they technically have like jurisdiction over it.
Yeah, I know. Like, I think it's pretty typical. I worked at a federal prosecutor's office last summer, and it's pretty typical because like almost every case can be wire fraud of some kind, especially because the internet is wires. It's pretty common for most cases like that, like white collar cases, to be investigated by like an FBI agent and a postal inspector.
So I guess another question, going back to what you said earlier, like I think it was near the beginning of the presentation when you were talking about basically what can overturn or overrule one of these like policies or I think, correct me if I'm remembering this wrong. I think you said that even if a court basically rules that an interpretation isn't, what was it? An interpretation isn't valid, the agency can still basically set policy that goes against the court ruling. Is that?
It would basically only ever happen like this. So if one circuit court in a faraway circuit, like they might be called to interpret this law outside of an agency action, and they say, we, the court, think the law means X, right? Then an agency in another circuit prosecutes somebody under that law. And they say, we're prosecuting you because we think this means Y. It comes before a judge who's not bound to follow the decision of that other circuit, but typically judges would. But because of the way that Chevron has evolved, they're supposed to take the agency's interpretation ahead of that other court's.
Okay. So
It's
actually,
not.
so basically it's saying, hey, like there is precedence, but it's not like, because correct me if I'm wrong, like isn't a lot of US law specifically based on like precedence? Like,
Yeah, all of it pretty much.
so this is a really weird example, I guess, where precedence isn't held to that same level?
Yeah, pretty much. And typically, it's basically like different courts in different circuits can disagree about interpretations of law, and they often do. And that's usually when a case will make it to the Supreme Court to resolve the difference. But it's just that agencies, that would only ever happen at like the second to highest court. And agencies are kind of at the lowest level. And what it is like when a court is reviewing what an agency's done, they're really not supposed to be deciding if they did the right thing. They're just supposed to be deciding if they did something that was permissible. And the actual standard is whether it was arbitrary and capricious or an abuse of their discretion. And when it comes to interpreting the law, if it's a reasonable interpretation, they're supposed to take that, even if other courts have said, we think the law means something different.
Okay.
So even if the Supreme Court has, in theory, has said that the law means something, if the law is ambiguous and the agency's interpretation is reasonable, the court is supposed to accept it. That's never happened, and it's not clear if that is how it would go, but you're right that it is pretty unique in American law. So that's one of the big reasons it's so controversial.
Nice.
Anything else?
Well, a legal establishment to the ground.
What's that?
Sounds like a major paradox that could break everything. I have a question.
Yeah.
Like if you go work for a big law, if you go work for big law, what fraction of the people at like your generic law firm are administrative law specialists, or is that not even a thing?
I think it depends. I think they wouldn't necessarily, it's less likely they'd be an administrative law specialist, and they'd probably be more of like an environmental law specialist.
Okay.
Or like a labor law specialist. But in a way, like pretty much all of environmental law is administrative law, and like because it all comes from EPA regulations. Pretty much all of labor law is administrative law. I think at like your fancier law firms that handle like appeals, or like often you'll lose your case in the district court, then you hire a different firm that like has appeals specialists to take it to an appeals court or to the Supreme Court. That's where you would get people who are more expert in like the APA itself, because that's when you get these, like you would get to the arguments about like, is the APA really, you know, from a policy perspective, does it jibe with the Constitution? But realistically, if you're just fighting about like, you know, did we dump PCBs into the river, you don't need somebody who knows about the APA. I mean, you need them to know it in the context of environmental law, but you don't need an administrative law specialist. I think administrative law is also sort of a favorite of law professors because there's so much of it.
Basically, there are a lot of like little oolies, like little like the not dependent on precedents. Like I don't want to say it's like fun for lawyers, but it's kind of like a
yes,
okay.
exactly. Yeah, it's great. It's people love writing articles about it, and like I think it's like Scalia was an administrative law professor before he was a judge, and like administrative law and civil procedure are like the big disciplines that professors love to do. Judges love to like, you know, judges often are experts in those before they become judges, especially on the Supreme Court. They're like the lawyers part of the law.
I've got a question.
Yeah.
Would you say that in its current implementation, this is the closest we are to like a Judge Dredd situation of one person being judge, jury, and executioner?
Yes, I think it's the closest we are, but hopefully it's not the closest that we'll get. I'm hoping that we can move closer to the Judge Dredd model.
Has the EPA ever like sent their EPA cops into somebody's place and they yell out like "I am the law" when they're like busting someone's door down?
I doubt it. Yeah, I doubt it. But if I were an agency employee, like running up on Elon Musk after he tweeted something, you'd be tempted to like have that feeling, you know.
I don't know. So growing up in Texas, I was always taught that basically game wardens are the Judge Dredd. Like a cop needs a warrant, but a game warden can come into your house at any time and like eat out of your fridge.
I don't know if that's true.
But that was what I was taught, and you know, Texas education.
I would think that like probably the Fish and Wildlife Service guys in the remote parts of the national parks are a lot more like that than the ones who manage like, I don't know,
lakes and stuff.
Roosevelt Island in New York City and like lakes. There is, just as a fun aside, and I was thinking about presenting about this, but it's quick enough that I'll just say it. There is a part of, I think, is it Yellowstone? One of the national parks called,
I believe it's Yellowstone, where it goes into Idaho.
Yeah, it's known as the murder zone because in theory, under federal law as it's currently written, you could commit any crime there and not be prosecuted, because under the Constitution, you're only allowed to be tried in the jurisdiction, in the district where the crime happened. But there has to be made up of a jury of people from the state where the crime was committed. And all of Yellowstone is in the District of Montana, but parts of it are in the state of Idaho. So in theory, if you commit a crime in that part of it, you couldn't be tried because they couldn't draw a jury of Idaho residents to go serve in a Montana federal court, and you wouldn't, in theory, be prosecuted. I'm sure they would find a way. And a very funny thing about that is it was discovered by some law professor who, as soon as he figured out that it might be possible, he published an article urging Congress to solve this problem before someone committed a murder. And he said he had to weigh, when he was writing the article, he was worried that a criminal would read it before Congress did. And they would go and commit all sorts of crimes there and be immune from the law. I think it did happen, and a guy just ended up pleading guilty, so it didn't get tested. But I can't imagine that would fly. But maybe they'll just do Judge Dredd out there. That seems like a good way to do it. Maybe
that's where Elon should move to instead of, you know, Nevada or Texas. Then he can commit all the security fraud he wants. And all that stuff.
That's true. Although the SEC, their jurisdiction is everywhere essentially, because you know, it's New York basically. Because if you trade stocks, you're trading them on the New York exchanges.
So I guess just out of curiosity, like going back, like using the Elon example, say that say that he was like a U.S. citizen doing essentially securities exchange, but for like the Toronto market or like in London. Does the SEC for him being a U.S. citizen in the U.S. doing that, would they have the same power to prosecute, or is he untouchable because it's committed in a foreign exchange?
That's a good question. I don't know. I'm assuming that I doubt they would find a way. Generally, I would have to know more about like the actual. It's Rule 10b-5 is the rule against the prohibit securities fraud, and there'll be some part of that that explains the jurisdiction. I would guess that like most of those laws, it's just like you have to have done something misleading that's material to the sale of securities. So
Okay.
that could count. And basically, if you've done something illegal, it won't help you that it involved a foreign country. Like the Foreign Corrupt Practices Act is a good example of that. Basically, it makes it illegal for American companies to pay bribes overseas. But I think the jurisdiction under that extends to like any company that's incorporated in the U.S. or that trades their stocks in the U.S. or like does business in it's basically like you can't get around it.
So it's a catch-all, basically, just if you're in the U.S., like this way we can touch you if you do something.
Yeah, for the most part. And like if you're here, you've had some connection. Like your money moves through American banks or something.
I was going to say there are a lot of ways they can jam you up just because of the power of the American finance system and the fact that you kind of have to get involved in it in some way or another if you want to do finance.
Yeah, if you're doing transactions in dollars, pretty much they can get you.
Okay.
So do you think that there's going to be like a food vendor in Zimbabwe that gets jammed up because he only takes dollars?
Probably not, but if he were to cash his checks at Bank of America, then yes. All right. Anybody got anything else?
So there was actually, I'm reading about the murder zone right now, and there was someone that wrote a novel that its entire plot was that someone was like just getting away with whatever they wanted in that area.
Oh, how did it end? Just doesn't say.
Oh. So, yeah, there was someone who was poaching in the death zone, and a federal judge ruled that the guy could still be tried in Wyoming, and the poacher's defense was basically the novel. Then the judge disagreed with it, and then the guy took a plea deal. So
Yeah, I had read that too.